Welcome to Examining the Legal History of Structural Racism and Its Impacts on Public Health. My name is Merlene Tucker, and I'll be running today's web forum along with my colleague Jeff Bornstein. Today's web forum is sponsored by Workforce Pathways for the Public's Health, a program of PHI Center for Health, Leadership and Impact, and produced by Dialogue for Health. Let's meet the moderator of today's event, Dr. Carmen Rita Nevares. Carmen is a senior advisor at the PHI Center for Health, Leadership and Impact, founder of Dialogue for Health, and senior vice president emeritus of external relations and preventive medicine at the Public Health Institute. Welcome, Carmen.
Thank you, Merlene. Welcome to everybody that's joining us today. We're very, very excited because we have 501 registrants for today's web forum. So we're hoping to reach a really broad audience. I see people are still signing in, and that's what we usually see at the beginning. So there's a little bit of intro we do here before getting started. Today's web forum is going to help you to understand what structural racism means and how it frames up the real choices and opportunities for communities to be healthy. And most important to this conversation, how you can understand law and policy in a way to help change these realities. Before we get started and I introduce our speakers, let me just let you know there are 4 speakers today, and then following that, we're going to have an opportunity to do a real interactive session where the Q&A is moderated by Cesar de la Vega and Amanda Fernandez, who are both from ChangeLab, and an opportunity to walk through their health justice framework. So we're really looking forward to a very, very interactive web forum today. Our first speaker is going to be Christine Camilleri, who is a senior planner at ChangeLab Solutions, where she engages in programs and projects that focus on the intersection between policy, built environment, and health equity. Christine previously worked at the New York City Department of City Planning, where her work centered on climate resiliency, community-based planning and outreach, environmental review, and zoning and land use. Christine also worked in post-disaster recovery during New York City's recovery from Hurricane Sandy, and in affordable housing development and preservation. Our second speaker will be Shannon Rempe, who's an attorney at ChangeLab Solutions, where she works to advance health equity in multiple program areas, including good governance and healthcare. Previously, she was the Health Law Fellow at the Kentucky Equal Justice Center, where she was co-counsel on a federal class action lawsuit fighting against unconstitutional medical debt collection practices in Kentucky. During law school, Shannon was a member of a legal epidemiologic research team for a project focused on racial equity and on the social determinants of health. And she was the lead editor of the St. Louis University Journal of Health Law and Policy. Our third speaker will be Heather Wong, who is an attorney at ChangeLab Solutions, where she contributes legal expertise to interdisciplinary projects at the intersection of law, public health, and equity. Before joining ChangeLab Solutions, Heather worked to ensure equitable access to legal counsel and defend the legal rights of system-impacted individuals in her role as an appellate public defender for the state of Colorado. And our final speaker is Melanie Thompson, who is an attorney at ChangeLab Solutions, where she works to advance health equity in several program areas, such as good governance and education. Before joining ChangeLab Solutions, Melanie worked at the University of California as a legal fellow and as a legal content specialist. During law school, she was an editor for the Asian American Law Journal and a judicial extern to Magistrate Donna M. Ryu of the United States District Court for the Northern District of California. So welcome to all of our speakers. And Christine, why don't you go ahead and take the mic?
Great, very happy to. Thank you very much, Dr. Nevares, for that introduction. And for anyone who is not familiar with our organization, I just want to start by providing a little bit of a snapshot of our organizational mission, which you can see is focused on supporting health through equitable laws and policy. And so the work we're here to speak with you all about today in this conversation is very much part of that work. And really building on that point, we have some core strategies for doing this work, and just want to highlight really just one or two of these really briefly for time, but they are all captured on this slide. One or two of our core strategies, I think that really relates to this work specifically, is supporting and building cross-sector partnerships and also elevating practical evidence-based and community-centered tools, solutions, and successes. And so we will touch on a few of these strategies over the course of the session today, and also share some resources in case you're interested in reading a bit more, learning more about our work after the session. And so I do want to just provide a brief disclaimer, which is, as you may have noticed, a few members of our team are attorneys. However, we are really only here today to share information, not to share legal advice. So just we ask that you bear that in mind. And in addition, the conversation today builds on work developed in partnership with the Centers for Disease Control and Prevention. But please note that the views that we are expressing in the webinar do not represent the official policies of the CDC. And the work that we are going to be discussing with you all today is the product of a ton of work by a lot of people and partners, including many of our colleagues at ChangeLab Solutions, as well as external thought partners from the Center for Disease Control's Office of Public Health Law Services, as well as the members of our wonderful expert review work group. Our heartfelt thanks go out to everyone for having the honor today of sharing this work. I also want to share a huge thank you on behalf of our whole team to the Public Health Institute for making this session today possible. In a moment, we will move through some foundational terms, frameworks, and concepts. Then we will move into examining the relationship between law and structural racism more specifically. Then we will pause for a brief 1-minute break before we move into some systems level examples and exploring the health justice framework before we pause for the Q&A session. We hope overall this session will allow us to meet a few key objectives, including discussing the legal history of the United States and how our construction of race has been shaped by centuries of law. We hope to support an understanding of how structural racism is woven into the fabric of our society, and how it directly results in the disparities we see today, with a focus on health. And we hope to support you in identifying action steps for pursuing health equity and dismantling racism using law and policy as tools for doing that. And so as we kick off the session today, I want to take a moment to name the critical, complex, and urgent nature of the subject matter that we're talking about today. I also want to recognize that different sections of this work will carry different weights and meanings for different people, as we understand that each person is coming to this session and really understanding it, engaging with it through the lens of their own unique experience. And that said, some of this content and conversation we hope may be enlightening, and some of it might be difficult, and some of it even painful. And that is because we are not engaging with this in a vacuum, and acknowledge also that distressing national and international news might add to the weight of this content that is already very, very heavy and emotional. And considering this, our whole team wants to extend an open invitation as we move into the session to everyone who's here today to do whatever you need to do to feel supported, including stepping away as needed. And please know that the content that we'll be talking about has been curated with a lot of intention to achieve those specific learning objectives that I mentioned, and the decision to include or exclude certain material was not taken lightly. And so after today's session, if you are looking to take action as it relates to law and policy change, our website is ripe with resources on the topic. At the same time, we know that some folks here might be interested in engaging and further reflecting on the personal side of this work, such as the learning and unlearning, the difficult conversations that may need to be had with others, and so on. We don't offer specific resources on that aspect of this work, but we do encourage you to seek those out as well. And so this is just, again, a snapshot of the agenda today, which I had already previewed with you all, just so you can see that. And I think just skipping along to the next slide, at ChangeLab, in one of our core publications shown on this slide, the Blueprint for Changemakers, we actually name structural barriers to health as a fundamental driver of health inequity. And so I want to briefly explain a little bit of what we mean by the 5 fundamental drivers of health inequity. We talk about this a lot at ChangeLab Solutions in our work, and we view these drivers as incredibly important because they help us to understand the upstream drivers of health for any policy issue area. And so when I say upstream causes, I want to explain what I mean by that briefly. I am talking about factors that impact health beyond individual level characteristics. And so we consider structural discrimination the primary driver of health inequity for a few key reasons. It encompasses and directly influences all of the other drivers that you see on this slide, which are poverty, disparities in opportunities like jobs and education, disparities in political power, as well as any governance that limits meaningful participation. Structural discrimination also leads to the formalization of that discriminatory intent within laws, systems, and policies, and it also reinforces existing prejudices, creates wider societal inequities and barriers to accessing the systems and resources that promote health and opportunity. And so it's for all of these reasons that we really at ChangeLab consider it incredibly important that all equitable policymaking work operate from the standpoint of acknowledging and seeking to remedy structural discrimination. And so we will return to these concepts as we move through today's webinar. And with that, I am going to pass the microphone to my colleague Shannon to move us into the next portion of today.
Thanks, Christine. So as previewed, this webinar is going to explore the legal history, oops, I went forward too far. The legal history of structural racism at varying levels, highlighting its role in creating health inequities and its impact on past, present, and future public health practice. To truly comprehend the legal history of structural racism in the United States, we must go back to the beginning, which we don't exactly have time for today, but in the interim, we will provide themes to guide those here through the construction of race in America and a framework for viewing the historical origins of racism in the law, as well as historical context for some of the laws that we've had in the past and for the ones that remain today. So as touched on, the hope is that this webinar can provide a foundation and build capacity for your work as public health professionals, addressing the racial and ethnic health inequities in your communities. So within the United States, there has been a persistent and intentional effort to miseducate people on the origins of racial inequities and the policies and norms which help to maintain them. Importantly, these inequities have persisted because laws and policies have enabled, sustained, and exacerbated the unequal treatment of people of color throughout history. We can counteract this effort for the purpose of racial healing, which recognizes the need for intentional truth-telling about the damage caused by racism at the individual and systems level, in order to restore people and communities to wholeness and affirm the inherent value of all people. And while we won't be able to cover all injustices and historical events today, we hope that the slice that we do present can start a conversation and hopefully spark action. So as a precursor to some themes that will come up today, let's start with a few definitions. First, racism is an organized social system in which the dominant racial group, based on an ideology of inferiority, categorizes and ranks people into social groups called races, and uses its power to devalue, disempower, and differentially allocate valued societal resources and opportunities to groups defined as inferior. And then race is primarily a social category based on nationality, ethnicity, phenotypic, or other markers of social difference, which captures differential access to power and resources in society. To further contextualize this, we can look to the Human Genome Project, which estimated that humans as a species share 99.9% of our DNA with each other. In fact, there's more genetic variation found within a race than between races. So from an anthropologist's view, race is nonsense. It can't be a biological concept, yet it is undeniably a social and political one. Racism also functions on multiple levels. So the most common understanding of racism in the US is often limited to the interpersonal level, being caused by internalized racism and defined as personal prejudice and intentional biases in individual interactions across races. But a more accurate explanation of racism provides that internalized racism is actually a symptom of a much larger, much more ingrained system of racism, one that includes cultural norms and institutional policies and practices that will routinely produce racially inequitable outcomes without regard to individual intent. This system of racism is what we will refer to as structural racism throughout today's webinar. To fully define structural racism, we must first define cultural and institutional racism. Cultural racism refers to the ideology of inferiority being instilled in the values, language, imagery, symbols, and unstated assumptions of the larger society, which often manifests through media and stereotypes and can be consciously or subconsciously adopted and normalized. And then institutional racism refers to the process of racism that are embedded in our laws, policies, and societal and institutional practices that provide for that privilege and oppression alluded to earlier. Thus, structural racism exists within and is reinforced and supported by internalized and cultural racism and multiple societal systems, including the housing, labor, and credit markets, and the education, criminal justice, economic, and healthcare systems. So to create some additional framing for this, I also want to introduce the concept of the hierarchy of human value. The belief that some people or groups of people are more worthy of experiencing well-being and the benefits of democracy, causing the general public to accept our current reality as inevitable rather than manufactured. So racism is founded on this belief, which is instrumental to pursue greed and justify economic systems that allow for the suffering of racial groups viewed as inferior and the showering and cascading of benefits onto racial groups deemed superior or white. The hierarchy of human value also carries a component of intersectionality and can use various social factors to prioritize individuals, such as based on class, disability status, gender identity, and sexuality. So this prioritization is what is often referred to as privilege, which can be defined by the benefits given to people who fit into a specific social group based on various aspects of their identity, including those we just listed, as well as religion, age, education level, immigration status, and language. Race, and more specifically whiteness, will be a central theme of this webinar. We defined race as a social construct, but throughout today, you will also recognize it as an economic and political tool, particularly for people deemed white. You'll also see how race is the product of racism, which we know because we see the formation of race in our laws and policies. Throughout history, whiteness has never been a static category. If we look at the laws of colonial America, whiteness was associated with Christianity. Specifically, if you were poor, being Christian promised classification as an indentured servant and not a slave. Colonial Virginia legally defined slave as, quote, any Negro, mulatto, meaning biracial, or Indian, meaning native, Jew, Moor, Mahometan, both meaning Muslim, or other infidel, and later language suggesting even if Christian behind any Negro, mulatto, or Indian would be added. So while xenophobia appears universally among human groupings throughout history, the American legal obsession with categorizing and ultimately inventing a white racial identity was motivated from the start by a need to justify the enslavement of Africans. This leads us back to that hierarchy of human value, which again brings together aspects of individual identity that can determine how individuals are viewed or treated in society, and the development of belief systems used to perpetuate this hierarchy, such as white supremacy, capitalism, or ableism. So in line with the different types of racism covered earlier, as we work through the remainder of this webinar, we encourage you to think about the ways public policies, institutional practices, cultural representations, and other norms perpetuate racial inequity. And especially as we work through some of our history in part 2, to think about how privileges associated with whiteness and disadvantages associated with color have endured and adapted over time. But before diving into part 2, I do want to provide some really brief legal history and a framework for understanding the legal origins of racism in the United States. So the history of this country starts when it was known as the New World, and the themes and beliefs that led to its exploration and ultimately colonization requires looking to the doctrine of discovery, which is an international law principle developed primarily by Spain, Portugal, England, and the Catholic Church in the 15th and early 16th centuries to maximize European colonization in the Americas and in other lands of non-European, non-Christian people. Specifically, under this doctrine, which was later written into American property law, the discovering country automatically gained sovereign and property rights in these lands, regardless of who was already living there. So with the doctrine of discovery defined, the United States must be perceived and analyzed as a settler colonial society, meaning it was created by individuals who arrived with the presumption of both entitlement and a right to establish permanent and exclusive control over the land. This presumption being fueled by racialized narratives of superiority and carried out by first removing, destroying, and replacing indigenous populations, then making the invaded lands profitable by importing slaves and exploitable labor. This pattern has been synthesized into the settler colonialism framework, which is made up of these 3 foundational processes upon which the US was built. In thinking back to the hierarchy of human value, this framework can be described as 1, the view of indigenous people as necessarily disappearing, 2, the view of Black people as enslavable, and 3, the view of immigrants of color as inferior and permanent threats to the country who must either be exploited or removed. With this framework in mind, we encourage you to take a moment to reflect. This includes observations and questions, which we will have time to answer towards the end. And now I'm going to pass it over to my colleague, Heather, to dive into part 2.
Thanks so much, Shannon. So we're going to be building on the foundational concepts that Shannon just introduced. And we're going to start with some additional context as we begin reflecting more on the relationship between law and structural racism. So as we just heard from Shannon, structural racism and other forms of oppression are reinforced across many different systems in our society. And these systems cumulatively drive the health inequities that we see today. So by shaping these various systems, law can play an important role in reinforcing or remediating structural racism. And in the next presentation, Christine is going to highlight some specific examples of what this actually looks like within a few different types of systems. But before we get there, let's just step back for a moment and contextualize these examples within our overarching constitutional framework here in the US. So let's start with the Constitution itself, which provides the foundation for our system of government and all of our other laws. Thinking back to the historical processes that Shannon described, we know that the Constitution emerged in 1787 from a hierarchical society built on the injustices of settler colonialism and racialized slavery. As legal scholar Maggie Blackhawk has written, we began with a constitution compromised by contested constitutional values, largely motivated by the inherited reality that the United States began as both an empire and a state that sanctioned and supported human slavery. For example, the Constitution was drafted against a backdrop of public international law, including the doctrine of discovery that Shannon just highlighted, that provided legal justification for the dispossession of Native nations. And as Professor Blackhawk has noted, the hierarchy between so-called civilized and uncivilized peoples that underpin this body of international law was reflected in the Constitution's distinction between foreign nations and Indian tribes. And as interpreted in later Supreme Court decisions, Indian tribes have inherent tribal sovereignty, but they're also deemed to be, quote, domestic dependent nations subject to the sovereign power of the US. The Constitution also reflected compromises on slavery to secure the support of Southern states. So this included provisions like ensuring that the slave trade remained legal until at least 1808, guaranteeing the return of enslaved persons who escaped to free states, and also the 3/5 compromise, which gave disproportionate power to Southern states by counting every 3 out of 5 enslaved persons in determining each state's number of representatives in Congress and presidential electors in the Electoral College. So in conceptualizing the ways in which our constitutional framework might perpetuate inherited inequities more broadly, I also want to briefly introduce the concept of a structural constitutional bias. So this concept was developed by legal scholars Jonathan Gold and David Posen to describe rules of the political game that, whether by design or by accident, and by interacting with demographic and political realities in changing realities, these rules systematically tilt the playing field for or against the policy objectives or electoral fortunes of one faction or another. And structural biases may be grounded in the text of the Constitution itself, or they can also flow from the larger web of documents, practices, institutions, norms, and traditions that structure our government. So according to Professors Gold and Posen, constitutional designers and reformers from the founding to the present have fought to create structural biases that benefit their agendas while preventing their opponents from doing the same. And as just one example, they note that large congressional districts were preferred by the framers in part because they advantaged large property holders who had more resources and connections to reach geographically dispersed constituents. And critics then and ever since have charged that this design feature, among many others, have stacked the deck in favor of private property rights, which were restricted to free white men like the framers themselves, and against economic redistribution. Another example of this that is the filibuster, which is a political tactic enabled by internal Senate procedural rules that can be used to block legislation unless it's defeated by a 2/3 majority vote. And when we look at this through the lens of structural constitutional bias, the filibuster, along with the many other institutional veto points in our lawmaking process, arguably puts a thumb on the scale in favor of the status quo and against ambitious legislation to tackle complex societal challenges like structural inequity. So even as various features of our constitutional framework may be further entrenching inherited inequities, it's also true that transformative social changes can and have taken place within this framework as well. And while we don't have time to go into detail on the various legal mechanisms through which this can occur, it's important to name generally that social change arises from a complex interplay involving formal political and legal institutions, as well as social movements and mobilized people acting both inside and outside of these institutions. So just as one example, the hard-fought civil rights movement of the 50s and 60s drew on a wide range of complementary strategies, including legal challenges in the courts, legislative lobbying, public education, media advocacy, and direct action to dismantle the Jim Crow system and advance racial justice in the US.
And I think I'm going to move us into some examples to help us think a bit more about how law can shape specific systems in ways that perpetuate or remediate structural racism. And so to kick us off, I'm going to briefly highlight 3 systems level examples: racial capitalism, spatial racism, and racialized citizenship. Of course, these are just 3 of many examples that exist. And I do want to underscore that all of these different systems intersect and work in tandem to reinforce structural racism. And so starting off with racial capitalism, the concept of racial capitalism first emerged in the context of South Africa's anti-apartheid movement of the 1970s. And it was further developed by US political theorist Cedric Robinson in the 1980s. More recently, racial capitalism has been described in the literature as, quote, a global system of racialized extraction in which race making operates as a means of stratifying populations for the purpose of facilitating profit making, end quote. And so one ongoing effect of this system is the racialized division of labor. And so this is on this slide, a figure from the Economic Policy Institute. And you can see workers who identify as non-white are disproportionately likely to be paid poverty level wages as compared with white workers. So, you know, it begs the question, how has law shaped racial capitalism in the United States? Again, we can go all the way back to how laws that facilitated settler colonialism and racialized slavery contributed to this. Both of those are forms of expropriation, which refers to the extraction of wealth from unpaid or grossly underpaid labor, land, or other assets under racial capitalism. And it's important to also note that these inequities can persist in new forms as our legal frameworks shift over time. We saw this after the 13th Amendment legally abolished slavery. The expropriation of Black labor continued to be facilitated through Black codes, Jim Crow, and other laws. And so even laws that are not explicitly race-based can also reinforce the racialized division of labor and resulting economic inequality. For example, some of the major federal laws that benefit workers in the United States, such as the Social Security Act and the Fair Labor Standards Act, have historically excluded groups that include disproportionately non-white workers and who are most vulnerable to expropriation, such as agricultural and domestic workers. And so moving into our next example, which is spatial racism, this is a concept that acknowledges the spatial enactments of racial inequality, including, quote, policies and practices such as residential segregation, incarceration, relocation, and differential access to economic, educational, environmental, and health development, end quote. And so, zooming into residential segregation specifically, this is an example and specifically a figure from the Brookings Institute, which shows how racially segregated residential patterns in metro US areas persist. Residential segregation is something that is talked about a lot in public health, and so we won't discuss this in great detail, but I do want to note that we can again think of the many examples of this system being shaped by laws, policies, and practices such as redlining, urban renewal, and exclusionary zoning, just to name a few. And it's really also important in the context of this conversation to recognize and name that public health has in the past been used as a justification for many of these harmful policies and practices that I just mentioned. A specific example is in the 20th century when urban renewal activities involved local public health departments that set guidelines and carried out inspections in the name of public health that supported the demolition of neighborhoods that were designated as blighted. And that led to the widespread displacement of predominantly low-income and Black communities. And then just moving into the third and last example in this section, we have racialized citizenship, which refers to the use of racial categorizations as grounds for assigning and taking away citizenship and the rights and privileges that come with that status. So the rules that define who has citizenship status are often determined by laws and policies, and these include rules governing naturalization, or how someone who is not born a citizen may obtain citizenship, as well as birthright acquisition, or how someone who is not born or who has citizenship status from the moment of birth, as well as denaturalization, or how citizenship may be revoked. And so when we look at US history, we can see examples of racialized citizenship within each of these types of rules. So for example, when Congress first defined the nation's naturalization rules and procedures in 1790, eligibility was explicitly restricted to, quote, free white persons, end quote. It was only in the 1950s that the last explicitly race-based restrictions on naturalization were eliminated, and only in the 1960s that immigration quotas based on national origin were abandoned. Looking at birthright acquisition, for example, the Supreme Court held that persons of African descent born in the United States do not have citizenship status in the 1857 case, Dred Scott v. Sanford. Dred Scott was nullified with the ratification of the 14th Amendment in 1868, and birthright citizenship was later extended to Native American people in 1924. Finally, an example of racialized denaturalization is the Denaturalization Act of 1944, which facilitated the coerced renunciation of citizenship by Japanese Americans who were forcibly relocated to internment camps during World War II. And so today, explicit race-based criteria is not used in US immigration policy. However, there are many examples of policies that have continued to reinforce structural racism and xenophobia in other ways. Looking to an example, yet another example of this, was a report from the Center for the Study of Social Policy and the Georgetown Center on Poverty and Inequality that had traced how federal restrictions on immigrants' access to public benefits, quote, were the culmination of decades of policy debates in which policymakers, think tanks, and the media vilified and scapegoated immigrants and Latinx immigrants in particular for the nation's ills and, quote, accelerated a radical process of exclusion that began shortly after immigration law opened the United States to more non-European immigrants, end quote. So that recognize that's a lot of information. I'm going to let that land while I hand it back over to Melanie to help move us into our discussion about the health justice framework.
Thanks everyone for setting the stage. I want to acknowledge that we've gone over a lot of difficult and complex topics so far. So again, as mentioned at the top of our gathering, please feel free to do what you need to do at any time to take care of yourself and be in this space and settle in as we discuss the health justice framework. So for those of you who are not familiar, the health justice framework on a high level is an approach to eliminating health disparities based on law and policy reforms that call out subordination as a key driver of disparities. And by doing so, the framework helps raise awareness of how our institutions and our systems are rooted in racism, social control, bias, privilege, all those things, ultimately resulting in poor health outcomes. And then in practice, the health justice framework is something that's really unique and radical in that it both broadens and complicates the traditional legal concepts of discrimination and common domains of healthcare and public health. Basically, that means that under this framework, law assumes a dual positionality. First, we accept law as one of the tools used to structure society in a discriminatory way, while institutional and interpersonal discrimination reinforce the discriminatory structure of our society. But on the other hand, law is also a key intervention that can address the structural determinants of health inequity. And so through this approach, we simultaneously seek to dismantle unjust laws to address systemic barriers to health and develop new or perhaps leverage existing but previously overlooked laws to promote health equity. Now, you might ask, how would we apply the health justice framework? On this slide here is a high-level overview. Basically, through a series of questions, the health justice framework examines the dual positionality of laws and policies, as mentioned earlier. We begin the framework with examining laws and policies that are already in place. And so this really means identifying a health harming law or a policy that exacerbates negative health outcomes through impacts on the social determinants of health. Following that, zero in on the known health harms of the law or policy, who is most harmed, and also you want to note any trends or even whether more research is needed to build the evidence base about these harms. Then finally, wrap all that up with identifying what actions individuals and organizational partners or potential partners can take to identify and mitigate the health harms. Once you have all that addressed, it enters the brainstorming phase. So that's asking, with what we have in place, what health affirming laws or policies can we replace with the health harming law or policy that already exists? How can stakeholders ensure equitable development and implementation of the health affirming laws and policies? What evidence is there to build or to strengthen the case for implementation? And finally, and this is key to the health justice framework, how might you prioritize, engage, and shift power to the communities that are most affected? And at the end of this process, you should have the beginnings to a game plan that 1, identifies a health harming policy, 2, identifies a health affirming policy to take its place, and 3, identifies how to center and empower your most impacted communities. If you'd like to learn more about the health justice framework, please check out the following resources featured on this slide. The first one is a 2022 American University Law Review article that we co-authored with Professor Talia Gonzalez, titled A Health Justice Response to School Discipline and Policing, which examines the framework in the context of education policy. The second is our 2023 Journal of Law, Medicine, and Ethics article titled A Health Justice Agenda for Local Governments to Address Environmental Health Inequities. And that one explores how you might apply the health justice framework in a local government context. I'll also note that these resources are really just two examples of the larger body of work out there on health justice more broadly. And so if this interests you, the two articles or the more broad health justice work that's out there, I believe we should have some links in the chat for your perusal on your own time. All right. And so in concluding our overview of the health justice framework, I do want to underscore how important it is to more closely examine the role that law and policy have played in enabling, sustaining, and exacerbating the deeply rooted injustices, and also to take action to develop law and policy solutions that eliminate those inequities. By using the health justice framework as a tool to aid our efforts, we can work to replace health harming laws and policies with health affirming ones instead, all while committing to prioritizing communities disproportionately affected by existing health harming laws and policies, engaging these communities, and shifting power to them throughout the policy development and implementation process. And again, by doing all this, we move closer to creating equitable policies, policies that can do things like initiate widespread change, sustain change over the long term, and ultimately undo historical policy-driven harms. And while all this might feel like a long-term goal or several long-term goals, there are still many concrete steps that can be taken today, in fact. So that might be something like establishing shared language and understanding of core definitions and values with your colleagues in your organization, forming or maintaining intersectional collaborations, and also other strategies for equitable policymaking. And so to that end, we mentioned the blueprint for changemakers earlier. I also want to alert you to our 2023 update to the blueprint, strategies for equitable policymaking, which you may want to take a look at to inform your exploration of health affirming laws and policies. And yeah, thank you. Thank you for your time. Thank you for your presence. I know this is a lot, but please don't hesitate to reach out to any one of my colleagues or me if you have any questions after the session. You can also subscribe to receive updates from us, ChangeLab Solutions, via the QR code.
Hi, folks. My name is Cesar de la Vega. First, I just want to say thank you to my colleagues on the ChangeLab team for that beautiful presentation and walkthrough. We're going to transition now to the Q&A portion, and we had a lot of wonderful questions coming in. We were able to address several of them directly in the chat, but we're going to bring some of those back to this main room for the entire audience to hear and engage with. So I thought we could actually start with the first question, which is folks were asking if we could please walk through an example of using the health justice framework. And so in order to do that, we actually have some slides available that if we can bring those back up, I'm going to have Melanie go ahead and walk through an example of using the health justice framework within the education space. Take it away, Melanie.
Sure. I'm back. I'm back, and I'm excited to take folks through the education example of walking through the health justice framework. As I talk, feel free to follow along using the example that you see here, or even follow along using your own example if you want to. You can take a piece of scrap paper or type in a separate document. So let's get rolling. So here we're starting with the first question, which is, what is a health harming law or policy that exacerbates negative health outcomes through direct or indirect impacts on the social determinants of health in your jurisdiction? As mentioned earlier, this is really the beginning of the framework. And so for our purposes, we'll use the example exclusionary school discipline practices. That might sound really broad or really specific to you, depending on who you are. But this is an example of something that might be standard. If you want to get more specific than that, that's really great. And so using this again as an example, something more specific than exclusionary school discipline practices might identify a specific type of practice, such as suspension or expulsion, three strikes rules, things like that. All right. Once you have that, you can move on to the second question. What are the known health harms of this law or policy? Again, using our example, we might think of lower academic engagement and performance, poor mental health, perhaps shown by increased rates of depression, PTSD, emotional distress. You might even think about diminished health protective factors. So that might be how close do students feel to their school? How connected do they feel, in other words? Or even risk of justice system involvement. For example, by showing how suspended students might be more likely to be arrested or on probation as adulthood in their adulthood. And so these are some examples to give you an idea. What's also really useful here is to note if more research is needed to build up evidence base around these harms. If you're a superstar, you might already be thinking of an article or some research that helps support your case. But if not, it's equally important to say what research might be needed to make a stronger case or to build your case. Moving on to question 3, who's most affected by these health harming laws and policies? Over here, you might want to note any inequities, any trends, so on and so forth. For you, again, using our example, there's a statistic that according to the Government Accountability Office, Black students accounted for 15.5% of all public school students, but represented about 39% of students suspended from school. And so that's an overrepresentation of about 23 percentage points. And additionally, national data shows that students who have disabilities are suspended 2 to 3 times more often than students without disabilities. And so in thinking of who is most affected by exclusionary school discipline policies, we might want to put BIPOC students, more specifically Black students, and students with disabilities. Moving on to question 4, what roles can individuals and potential partner organizations play in identifying these health harming laws or policies and ensuring that they are eliminated? Here, you can parse the answer out by individual and partner organization, and even divide the partner organization category further. For example, in the schools context, you might want to have a segment thinking about community-based organizations and another one thinking about school districts. Our sample answer here lists 3 categories and their unique roles that they play. So organizations who can commit to increased transparency and accountability, individuals who can give a more on-the-ground perspective of what's working and what's not, and help course correct in certain situations, and then also school districts, right, who can commit to divesting from health harming policies. All right, question 5. We're almost there, folks. What health affirming laws and policies, that support individual and community well-being might be advanced to replace those eliminated? Here's a really fun place where you can note really creative answers. Here we are using answers that are evidence-based, if possible. For example, for us, we're listing things like restorative justice practices, social and emotional learning, um, things of that nature that have evidence base, but which, depending on where you look, might have a need for more evidence base, especially once you get into the specifics of like equity and inclusive practices that are really resonating with your specific demographic. Okay, question 6. What roles can individuals and potential partner organizations play in ensuring equitable development and implementation of these health affirming laws and policies? So the sample answer here, you'll note, names potential partners, again, individuals, organizations, school districts, and also the roles that they could play in equitable policy development. So that's things like shared visioning and identification of health affirming policy solutions, involvement in policy design, as well as implementation and evaluation. And that lands us to question 7. How might you prioritize, engage, and shift power to the communities that are most affected as identified in question 3? So for our example, you'll want to recall that we identified Black students and students with disabilities as 2 impacted communities. And then also note that the sample answer provides that you can prioritize by being a public health ally. So for example, by bringing public health methodologies to lead and or support calls for reform in a way that centers voices of impacted communities. Can engage the communities by engaging students, their families, communities, and that they're a part of throughout the whole policymaking process, integrating them with community-driven movements, and also serving as collaborative partners and conduits to uplift often overlooked public health implications of existing laws and policies. And third, you can shift power to these communities by taking on supportive, not leadership roles in these movements. Again, this is a moment to be really creative, to identify how power can be shifted, giving communities most impacted a seat at the table, for example, for participatory processes like budgeting and decision making, or you might even want to take it further back and like take a look at the communities and see what assets are there and how they can be leveraged. Yeah, and that takes us through the end of the walkthrough of the health justice framework using our education example. I'll pass it back to Cesar and Amanda.
Thank you, Melanie. We really do appreciate that walkthrough, and I hope that was helpful for folks who are interested in seeing the application of the health justice framework. There was a question that came up whether we share the questions that are included in the framework, and the answer is yes. We have a worksheet, and we can share a PDF copy of that worksheet so that folks have those questions available to them. So thank you so much for those who raised questions around the health justice framework. I'm going to pass it to my colleague Amanda to tee up our next question for Q&A.
Hi, everyone. I'm Amanda Fernandez. There was a question that was put into Q&A on how they haven't connected the dots on why the large congressional districts support the dominance of landowners, and asking if we could please explain how it gets operationalized and whether that's still the case today. I'm going to pass this over to my colleague, Heather.
Thanks, Amanda, and thanks for that question. That's a great question. I think on the specific point about the large congressional districts, the point there was just that, we can imagine that it would require a lot more resources, money, connections, in order to be able to be competitive in elections that where you need to win over a larger geographic area and a lot of people, so that would advantage people who have more of those resources. And that, still makes, sense to some extent today. I think another point that is the question is raising that I really want to pull out, because I think this is a great point that Professors Gold and Posen make really explicit in this article, is the fact that structural biases, they're not they're not necessarily constant, right? They're operating in a specific political context, and so they can ebb and flow, and they can even reverse course at some point, depending on the realities on the ground, and that could be, geographic, demographic, partisan kind of shaping patterns that emerge. And so I think the point here is to really, be thinking about these kind of structural biases in our specific context, be thinking about, why are there certain types of laws that might be harder to enact or others that are easier to, and what are kind of the structural design features behind that, and then thinking about opportunities to kind of tackle that either from a constitutional design point of view, or even taking advantage of natural shifts in geography, partisan distribution, demographics, and things like that. Yeah, I'll stop there. Thanks.
Thank you, Heather. Appreciate the clarity and the additional context around that question. Another question that came up in the Q&A is, does the discrimination of health equity and barriers to health also include incarcerated citizens? And for that, I will ask Amanda to share some thoughts.
Yeah, I think this is a great topic to bring up. I mean, mass incarceration is definitely a public health issue. If you've read The New Jim Crow by Michelle Alexander, the thesis of which that the US criminal justice system is a contemporary system of racial control, and it's similar to slavery. And so instead of ending a racial caste system in the US, we've just redefined it, we've just redesigned it, I mean. And so if we accept that premise, which we do, that mass incarceration and systems of incarceration and criminal legal policies and laws are just another form of racial control. And we see how ruinous jails and prisons and other carceral settings are to an individual's health, and also not just people who are on the inside. People who are currently incarcerated are so much more likely to have health issues. We know that people of color, Black, Indigenous people of color are much more likely to become incarcerated, largely in the first place. And so it's ruining people's health in a way that's really, and that's very racialized. And also not just the health of somebody who is inside, again, as I said, but because we know having an incarcerated parent is an adverse childhood experience that has health consequences as well. And also if there's their partner, it's leaving, the child with only one parent, maybe if one parent is incarcerated. And so that other partner who is managing the stress of raising a child alone and having to work multiple jobs, that has ruinous health consequences. So you can understand like the damage that this does on such a large scale. It would be impossible for it to not be a public health issue. And we just going to the example of COVID, we saw how congregate settings like jails and prisons, and how ruinous it was during COVID, and how COVID could just tear through jails and prisons and other congregate settings, combined with the inadequate healthcare that we frequently provide in jails and prisons. And then also dealing with a population who, by virtue of being there, is already, and because of the conditions in jail and prison, is already more susceptible and more likely to be experiencing myriad health problems. It was truly devastating. So that's what so absolutely, we view mass incarceration as a public health issue, and the system of incarceration as a form of racial control. Does anybody else have any other thoughts on that before we move on to the next question? I know it's a really weighty topic. I wish we could get more into it. I'm going to pass it over to Caesar to discuss. There was a question about, are you going to address institutional racism within public health departments, both with employees and with programs, policies, and services to the public?
Thank you, Amanda. That's a great question. And to answer that, I'm going to take folks a little bit behind the curtain and share that, with the limited amount of time that we have to do these presentations, we opted to focus specifically on laws and policies at a broad level for this session. And I think there's certainly an opportunity and space for further exploration of, okay, we got this history, we learned about this history, we received some key vocabulary terms. Now, how do we take that and bring it in-house with folks? How do you all take these learnings and understandings of the legal history of structural racism and use that to tee up conversations within your respective public health departments, right? Within the public health departments, we see not only institutional racism, but we can also see interpersonal racism. So although this wasn't a focus of the session today, it's certainly a critical piece of the work, right? You want to ask yourself, how does this all manifest internally within our department? Are there specific policies, practices, and or services that are problematic? Do they, for example, exacerbate racial health inequities when they're aiming to improve those inequities? So I think it's a great question. Unfortunately, it's a little beyond the scope of our session today, but we do encourage you all to take, again, some of the key terms, the vocabulary, the systems of racism slide, for example, I think is a wonderful slide to use to tee up a conversation internally within your respective departments, organizations, agencies, to have a conversation about, hey, what's going on internally here? What institutional racism do we need to address in order to do our work more effectively? So thank you for raising that question during the Q&A. There was also a wonderful question, both a comment and a question in the Q&A. And this person noted or asked if we were going to discuss public pool access when we were talking about structural racism and the built environment. So I just want to name again, in the interest of putting together a session that would fit within the allotted time we have with you all today, we weren't able to address every example, but the public pool access is a very powerful example. And one thing that we want to do when we deliver these sessions is encourage you all to think about, hey, you know, we heard some examples today around racial capitalism, spatial racism. What are those examples local to us, or those examples that would most resonate with our audiences? Is it an example around the built environment and public pool access? Might it be around the built environment and park access, or the construction of freeways and what that's meant for environmental harms and impacts on things like air quality? So, you know, the session today isn't meant to be entirely comprehensive, but we hope it does encourage folks to look to your own communities, look to your own context that you're working in, and think about what are those examples that would most resonate with the audience that we're trying to reach when we're talking about this legal history of structural racism. There was also a follow-up question attached to that regarding reparations and the idea of tying reparations payments to municipalities rather than individuals, which can be harder to prove. So I do want to open up to my team to see if there are any thoughts about examples or things they've seen around this idea of trying to tie reparations payments to municipalities rather than individuals.
I don't have like a ton of information, but I can speak a little bit. I did really appreciate that question. I also immediately thought of Heather McGee's work and the California reparations report. It's very long, but I did attend a presentation on it this past spring, and it was super interesting. And the projects that they're trying to do off of that also sound really great. The only example that came to mind, like off the top of my head, as far as municipalities, was a couple years ago. There were a bunch of mayors that developed like pilot projects for reparations. I don't have like information about where that went. But definitely, you know, looking to the government and not individuals is going to be the easiest approach. But yeah, that was a great flag. Really appreciate all the the comments and questions that have come in, but sorry, we don't have a ton of information on that specifically. I don't know if anybody else has thoughts they want to chime in.
Thank you, Shannon. We appreciate that. And I did see our colleague also dropped a link to that report. So many thanks for that. Just doing a time check. I see we have about 10 minutes left. So Amanda, maybe we should move on to the next question.
Yeah. So we know that this was a bird's eye view of the legal history of structural racism. And I wanted to, and it would be impossible to cover everything, but I wanted to ask you, Caesar, if there's anything, or anybody else as well, if there's anything you'd like to add about how present day laws and policies are either upholding or dismantling racial inequity.
Yeah, thank you for that question, Amanda. Unfortunately, I think in recent years, we've started to see a bit of blowback, or sort of a bit of pushback to our progress and efforts around racial equity. We're seeing more and more jurisdictions restricting the ability, for example, to like explicitly use racial equity as sort of a driving force in the work. So laws and policies are being passed to limit the ability for folks to use race in policy making. So I think what the takeaway for me is that this battle is ongoing, right? We're talking about this legal history, but it's important to remember that history is happening today in this very moment. So it's not only important to understand this historical context to tell the story, but it's critical to connect that to present day actions and efforts around laws and policies that can dismantle or can uphold rather racial inequity. Similarly, though, there are those glimmers of hope and inspiration of folks who are using laws and policies in a creative way to dismantle racial inequities. Folks sometimes, when they are facing more restrictions, for example, at the state level, may locally choose to use racially neutral approaches to law and policy that still are designed to have those intended impacts on reducing racial inequities, but aren't naming them in an explicit way. So I think folks are becoming increasingly creative in navigating some of those present day limitations and challenges around addressing racial equity explicitly. I'll pause to see if any of my ChangeLab colleagues have any additional ideas or thoughts on that.
Thanks, Caesar. I have one little just add on the importance of creativity when we're still thinking about like continuing efforts towards equity, diversity, and inclusion. When I was a legal fellow at the University of California, we had a lot of restrictions in terms of like whether or not, like, you know, we can't count people, for example, because of our legal restrictions, but we can count efforts. And so when we were thinking about like external vendors and like who we want to contract with as the University of California, we ended up innovating an outside counsel DEI report card program that examined our outside counsel's efforts towards DEI inclusion. And so when we are, again, as you said, in the midst of history where there's a lot of blowback, there's always an innovative solution, I think, when folks put their heads together, if that can be a little nudge towards, I guess, keeping people hopeful that despite the blowback, there's still work to be done, and the importance of efforts that we do too.
Thank you, Melanie. We appreciate you sharing that uplifting example. One other thing that I'll share for folks is you don't have to do this alone, right? There are a lot of people who are thinking about this challenge and thinking about how present day laws and policies are either upholding or dismantling racial inequity. And one example of that is a space called the Collaborative for Anti-Racism and Equity. And that's a group of folks who are gathering resources and sharing them with the public on doing racial equity work. They're producing original research. They're collecting research that others have done and are uplifting that research to help folks who are on their journeys. This collaborative also hosts quarterly peer learning communities where you have a space to join and have conversations with other people who are engaged in the work in a similar way. And it's really just a wonderful space to be in community with others who are maybe grappling with similar questions, similar struggles, and or folks who can share examples that bring hope and inspiration to you all on that work.
I know, so we talk a lot about the importance of centering communities that are disproportionately harmed by structural racism when using legal and policy tools to pursue equity. Do you have any tips or resources for how to do this?
Yeah, great question. So as you all heard when Melanie was talking about the health justice framework, right? One of the tenets of that is to prioritize, engage, and shift power to communities most affected by these laws and policies. So what does that mean? Well, here at ChangeLab, when we talk about policymaking and equitable policymaking, we really do aim to center communities who are most disproportionately harmed by structural racism when developing those laws and policy solutions moving forward. So that means engagement, not only, we want to get the community support on a policy, but no, let engage with folks at the outset when you're in that ideation phase and having conversations about what are the needs and challenges of a community, what are the things that folks are excited about and want to take action on. So really engaging with folks throughout the policymaking process from conception all the way through to implementation. And even after implementation, when you get into evaluation, right, you want to make sure that once a policy has been passed and is being implemented, you want to make sure that that policy is actually having the intended impacts that it was designed to have. So how do you do that? That means you got to talk to folks in the community and make sure that, this policy is supporting them in the way that it was designed to. And if it's not, what can you do to course correct and make sure that you're minimizing any unintended consequences of that policy? So I think really when we're talking about how to do that, it's just holding the time and the space to engage with folks in an authentic manner and in a manner that really lifts up the power that they already possess and hold, but creates spaces to channel that power and lead to direct impacts on the policymaking process. Do any of my colleagues have any additional thoughts to share on that question?
I could chime in really quickly, knowing we're short on time, Caesar,
Sure.
just like kind of bringing this, building on what you just said. I'm just thinking about, that in terms of very local policy processes and like how what you just said, what that actually means, like operationally, when you are looking at, for example, we talked about spatial racism and local land use processes and just recognizing that what you just mentioned, acknowledging that some of what is needed to do that sort of proactive community engagement might mean building infrastructure to do that. So recognizing that might mean compensating people for their time, educating people, about what those local processes, state processes, whatever scale you're working at might mean, and also building trust, and like these are not things that necessarily can change over time, recognizing, looking back and forward at the same time at the harm that's been done, and really closely having difficult conversations around, what is needed to rebuild those relationships with people, involved in making laws and policies. So just like wanted to add those kind of specific, like more operational things onto the wonderful points that Caesar just made.
Thank you, Christine. We appreciate that. And we will pass it back to our friends for our closeout. Thank you all for your time. We really appreciate the engagement.
So thank you so much to ChangeLab Solutions. This was such a layered, such a nuanced and very important conversation. And thanks so much for helping to tee that up. We know there's still so much more to say. I want to make sure that everybody knows that if you want to get your continuing education credits, you have to complete the survey at the end, which you're going to get as a link in the chat box right now. And then thank you to everybody who participated today for the really great questions and the thinking. And I know there will be more thoughts going forward. And I want to remind everybody that the date for our next Dialogue for Health Public Health Infrastructure Grant event is Thursday, the October the 24th. And please join us for that. So thank you and goodbye.